The hospital room on the 9th floor of St. Joseph's, overlooking Lake Shore Drive in Chicago, kept the same rhythm every morning. A card in the hallway at 6. A blood pressure cuff at 7. A tray of food that would mostly go untouched, because Marshall Davies, a retired city engineer with a broken hip and a mind that had already begun to slip, had stopped being hungry the way he used to be hungry. He did not know, in January of 2008, that the woman assigned to his floor that week would end up controlling nearly $1 million of his money. He did not know that within 4 months she would hold a legal document giving her the power to sign his checks, sell his home, and speak for him in rooms he would never enter. He did not know that the doctors who treated him had already begun writing the word dementia into his chart, and that this word, more than anything else, was what made him valuable to the person who was about to become the most important relationship left in his life. Marshall Davies was 90 years old when it happened. He had spent his working life as an engineer for the city of Chicago, decades of unglamorous, essential work, the kind that keeps a city's infrastructure standing without anyone ever learning the names behind it. He had never married. He had no children. He had, by the time he arrived at that hospital, a pension, a modest retirement, and a decades-long habit of trusting people who wore scrubs. He was, in the language the courts would later use, extremely vulnerable. He was also, in the plainer language of the people who knew him, simply alone. Not abandoned, not neglected by anyone in particular, just a man who had outlived the version of his life that included regular company, left with a hip injury, a diagnosis he didn't fully understand, and a hospital system that needed to discharge him to somewhere. That somewhere is where this story actually begins. Not with a crime. With a gap, the ordinary, unremarkable gap that opens up around any elderly person with no one checking in, and the extraordinary speed with which someone can walk into it. Her name was Carmelita Pasamba, and this is the story of what she took, how she took it, and what it cost her when someone finally noticed. Welcome to PalimpSestCrimes. If stories like this one matter to you, hit subscribe. There's a new case waiting every week, and your support genuinely keeps this channel going. Carmelita Pasamba was a certified nursing assistant at St. Joseph's Hospital when Marshall Davies was admitted. She was in her 60s, originally from the Philippines, and by every account from her co-workers, she was good at her job in the specific way that mattered most in a hospital. She was attentive. She remembered names. She sat with patients who had no one else sitting with them. Marshall Davies had hip pain that kept him from walking without assistance. The hospital's position was clear before he was discharged. A man his age, with his cognitive state, could not be sent home to live alone. He needed round-the-clock care. The hospital's own recommendation, according to later court filings, was a licensed 24-hour home health agency, a company, with employees who answered to supervisors, with billing records that someone besides the caregiver herself would review. Marshall Davies did not choose that option. He chose Carmelita. It made a certain kind of sense. She already knew him. She had already spent weeks at his bedside, and in a hospital room, weeks can feel like years to a man with no other visitors. When he left the hospital that January, she went with him, first as an employee, then, with startling speed, as something else entirely. There is a particular kind of trust that forms in a hospital room between a patient with no family in the waiting area and the one person who shows up every shift. It is not manufactured, not usually. It is often completely genuine on both sides, in the moment it happens. That is precisely what makes this category of crime so difficult to see coming, and so difficult to prosecute after the fact. Nothing about the beginning of this relationship looked like exploitation. It looked like the opposite. It looked like exactly the kind of care an isolated 90-year-old man was supposed to receive and almost never does. Within 3 months, Carmelita had brought Marshall Davies to the office of an attorney named Alfonso Boscos, a member of the Filipino-American Council of Greater Chicago, whose office sat inside a community center on the city's north side. There, in April of 2008, Boscos drew up 3 documents that would define the rest of Marshall Davies's life: a new will, a new trust, and a power of attorney. The power of attorney gave Carmelita control of his finances. The trust named her family, and several charities connected to Boscos' community organization, as the primary beneficiaries of his estate. Marshall Davies signed all 3. 2 witnesses signed beneath him. One of them would later tell a reporter, in Tagalog, that she had been told simply to witness because a donation was being made. She had not been told what she was actually witnessing. Here is the part of the story that unfolds slowly, in a way that true crime rarely captures well, because there was no single moment of violence, no single decision that a jury could point to and say, "There, that is where it turned criminal." It happened in installments. It happened the way water finds every low point in a foundation before anyone notices the house is sinking. 2 weeks after Carmelita obtained the power of attorney, on the 8th of May, 2008, she wrote herself a check from Marshall Davies's account for $30,000. She was legally entitled, as his power of attorney, to a fee of $8.25 for her role. A month later, on the 16th of June, she wrote herself another check. $25,000. She called these transactions loans. She used the money to remodel her kitchen and her basement. The loans were never repaid. In October of that same year, acting as his power of attorney, she oversaw the sale of Marshall Davies's condominium. It sold for a little over $189,000. From the proceeds, Carmelita paid herself a $50,000 bonus. She put $10,000 down on a new Mercedes-Benz. Her husband, Edgardo Pasamba, became its driver. From September of 2008 through July of 2011, Carmelita paid herself a monthly salary of $5,500 for her duties managing his finances, a total of $170,000, on top of everything else. Her sister, Jocelyn Baker, also a certified nursing assistant, joined the arrangement as a second caregiver. She received more than $20,000 beyond her salary, which she used to remodel her own apartment and buy new furniture. By the time investigators finished tracing the money, Carmelita Pasamba had withdrawn $749,100.03 from Marshall Davies's accounts. Jocelyn Baker had taken $60,840. Carmelita's adult son and daughter had taken smaller amounts on top of that. In total, the family removed $753,600.03 from a man who could no longer reliably remember what day of the week it was. There was an iPhone. There was an iPad. There were vacations. Carmelita, according to a colleague who later spoke to investigators, began talking openly at work about her new money, her new car, her husband's new job as a driver. She did not appear to be hiding anything. That, in the end, is what makes this case so unsettling. She did not act like someone who believed she had done something wrong. Somewhere in the middle of all this, a hospital nurse named Cindy Rubio, a colleague of Carmelita's, someone who had also known Marshall Davies from his time on the ward, began to grow uneasy. Illinois law required her, as a licensed nurse, to report suspected financial exploitation of an elderly patient the moment she suspected it. She did not report it to the hospital or to Adult Protective Services. Instead, according to the record, she confided her concerns to a former caregiver of Davies's, telling her she was worried Carmelita was financially exploiting him, and that she feared what might happen to her own position at the hospital if she said so out loud to the wrong person. That single decision, to voice a suspicion privately instead of formally, is one of the quieter tragedies buried inside this case. It was not malice. It looks, from the outside, like fear of accusing a colleague, fear of being wrong, fear of professional consequences for speaking up. But the gap between suspecting something and reporting it is exactly the gap that exploitation depends on to keep running. Rubio was later named in the Public Guardian's original citation to recover assets, though she was ultimately released from liability as part of the hospital's later settlement. Nothing about this story required a genius. It required, at almost every stage, only one working adult with legal authority to ask a harder question than they were being asked to ask. For 3 years, almost no one did. Before we get to what happened to her, if you're the kind of person who needed to know how deep this went, that's exactly what this channel does every week. Hit subscribe now so you don't miss the next one. Okay, here's what happened when the grand jury got involved. By early 2011, Marshall Davies was 93 years old and had been diagnosed with severe dementia. He could not, by that point, reliably state his own age. That same year, an organization called Catholic Charities Older Adult Services, a non-profit whose entire function is to receive and evaluate reports of suspected abuse of adults over 60, received 2 separate anonymous reports concerning Marshall Davies. Someone, somewhere in his orbit, had noticed enough to make a call. Catholic Charities petitioned the court for a guardian. Their petition stated plainly that Davies had severe dementia and that the person holding his power of attorney, Carmelita, had not been forthcoming about what she had done with his money. On the 7th of July, 2011, the Cook County Probate Court appointed the Public Guardian's Office as his temporary guardian. An assistant public guardian named James Burton took the case. What Burton found, once he started pulling bank records, went beyond simple overspending. Buried in the paperwork was a document dated the 30th of April, 2008, a note, purportedly from a physician named Dr. Predrag Simovic, attesting that Marshall Davies showed no signs of memory loss at the time he signed his new will and power of attorney. The problem was that the document had been fabricated. Marshall Davies had already been showing documented signs of cognitive decline before that date. The note existed for one purpose: to make the estate documents look unchallengeable if anyone ever asked whether a man with dementia was competent to sign away control of his finances. This is the detail that turned a civil dispute over money into a criminal case. It is one thing to spend an elderly man's savings and call it a loan. It is another thing entirely to manufacture a doctor's signature to protect the paper trail in advance. The forgery was not an act of panic after the fact. It was insurance, created at the very moment the scheme began. When investigators laid the 2 versions of Marshall Davies's medical history side by side, the real one, showing early signs of cognitive decline, and the fabricated note claiming a clean bill of mental health on the exact date the estate documents were signed, the contradiction was not subtle. It was the kind of detail that, once found, unravels everything built on top of it. If Carmelita had never created that note, her lawyers might have argued later that Davies was lucid enough that spring to understand exactly what he was giving away. The forgery removed that argument before it could ever be made, because a person does not fabricate proof of someone's soundness of mind unless they already know, at some level, that the soundness is in question. In April of 2013, a Cook County grand jury indicted Carmelita Pasamba, her husband Edgardo, and her sister Jocelyn Baker. Carmelita alone was charged with an additional count, forgery, for the fabricated doctor's note. The charges against her were severe: financial exploitation of a senior citizen, financial exploitation of a person with a disability, theft between $100,000 and $500,000, theft by deceptive practice, and forgery, 8 separate counts tied to that single falsified document. She was 62 years old at the time of her arrest. Bond was set at $350,000, payable in cash, in order for her to walk free while the case proceeded. Her sister's bond was set at $200,000. Her husband's at $50,000. None of the 3 had any prior criminal record. Not a single arrest, not a single conviction, in any of their lives before this. That fact matters more than it might seem to at first. Financial exploitation of the elderly rarely involves career criminals. It is committed, in the overwhelming majority of documented cases, by people who have never been in trouble with the law before and who, in nearly every other part of their lives, are considered trustworthy: a family member, a neighbor, a caregiver, someone with no criminal history to raise a flag on a background check. Carmelita Pasamba was, by the accounts of her employer, a competent and attentive nursing assistant for years before any of this began. The absence of a criminal record is not evidence of innocence in these cases. It is, more often, the precise condition that allows the exploitation to begin in the first place, because no one is looking for a threat that doesn't match the profile of one. The criminal case moved slowly, the way financial crime cases involving elderly and cognitively impaired victims tend to move: years of depositions, forensic accounting, and legal maneuvering by several different defense attorneys hired over the course of the litigation. At one point, the defendants attempted to pause the public guardian's civil recovery effort entirely, arguing that answering questions in the probate case would force them to incriminate themselves in the pending criminal one. An Illinois appellate court eventually ruled against that argument, allowing both cases to proceed on separate, simultaneous tracks, a decision that meant Marshall Davies's estate did not have to wait for a criminal verdict before beginning to recover what could be recovered. The civil case moved in parallel. St. Joseph's Hospital, which employed Carmelita and which, under Illinois law, had a legal obligation to report suspected abuse once a nurse raised concerns internally, eventually settled with the public guardian's office for $250,000. The hospital admitted no wrongdoing. It settled, according to the agreement, to resolve the matter without further litigation. Attorney Alfonso Boscos was never criminally charged. He maintained publicly that he had believed Marshall Davies was lucid and competent when the documents were signed, and that he had been, in his own words, surprised and angry when he later learned what Carmelita had done with the access those documents gave her. Whether that account is complete is a question the public record does not fully resolve. He was named as a respondent in the civil recovery proceedings but faced no criminal indictment. In late 2015, Judge Joseph M. Claps of the Circuit Court of Cook County accepted Carmelita Pasamba's guilty plea. She pleaded guilty to one count of financial exploitation, drawn from the original 11 counts against her, and was sentenced to 6 years in the Illinois Department of Corrections. She then pleaded guilty to forgery, drawn from the separate set of 8 counts tied to the fabricated doctor's note, and received an additional 5 years. Because Carmelita had overstayed a visitor visa decades earlier and had no legal status in the United States, she faced likely deportation once her sentence was served. Her sister Jocelyn, who also had no documented legal entry into the country, faced the same outcome. Before sentencing, in comments to a local news reporter, Carmelita offered something close to an admission, saying simply that she now understood what she had done was not right. It was the closest thing to remorse that made it into the public record. It would be easy to file this away as a story about one dishonest caregiver. That would also be a mistake, because the mechanism that made this possible is not rare. It is, according to the people who study it, one of the most common and least visible crimes committed against older Americans. The National Council on Aging estimates that financial exploitation costs older adults in the United States at least $28 billion every single year. Research from AARP found that roughly 72% of that money is taken not by strangers running phone scams, but by people the victim already knows and trusts, family members, friends, and caregivers. Marshall Davies had almost every risk factor that researchers now point to as warning signs. He lived alone. He had no spouse, no children, and no one checking his accounts regularly. He was cognitively impaired in a way that made him easy to isolate and easy to influence, and difficult to cross-examine later about what he had actually agreed to. What ultimately stopped it was not a family member noticing. Marshall Davies had no family checking on him. What stopped it was a mandatory reporting system working exactly as it was designed to, an anonymous call, twice, to an organization whose entire purpose is to catch exactly this kind of exploitation before it becomes irreversible. It nearly didn't happen in time. By the point Catholic Charities intervened, 3 years had already passed. $753,000 was already gone. The professionals who study elder financial abuse point to a few concrete protections that could have changed this story much earlier. The first is an independent legal review. Marshall Davies signed away control of nearly $1 million in a single meeting, with an attorney his caregiver selected and drove him to, with no outside counsel ever weighing in on whether the arrangement served his interests. An attorney with no prior relationship to the caregiver, retained separately and paid separately, is one of the simplest safeguards against exactly this pattern, and one of the least commonly used, because by the time it matters, the person who most needs that protection is usually the one least equipped to ask for it. The second is bank-level monitoring. In the years since this case, a number of major financial institutions have adopted software that flags unusual withdrawal patterns on accounts belonging to older customers, a sudden large check, a new joint signer, a series of round-number transfers that don't match a person's normal spending history. None of that infrastructure existed in a form that would have caught Carmelita's withdrawals in real time back in 2008. Some of it exists now, in part because regulators studied cases exactly like this one. The third, and probably the most powerful, is simply consistent contact. Isolation is not an accident in these cases, it is very often the mechanism. Marshall Davies had no one checking his mail, reviewing his bank statements, or asking him plainly what he had signed and why. The people legally required to notice, his hospital, his attorney, each had their own blind spots, whether through negligence, misplaced trust, or fear of consequences for speaking up. The people who might have noticed as family never existed at all. A regular phone call, a monthly look at a bank statement, a single outside adult asking, "Who has access to your money right now?" None of it guarantees prevention, but nearly every documented case of elder financial exploitation includes long stretches where nobody was asking. Marshall Davies remained under the protection of the Cook County Public Guardian's Office for the remainder of his life. The recovered settlement funds, along with what could be clawed back from the Pasamba family under the terms of their agreements, went toward his ongoing care. He never fully understood, according to those close to the case, the scale of what had been taken from him. His dementia had progressed too far by the time the truth surfaced for him to process it the way a younger, healthier man might have. In some ways, that may have spared him something. In every other way, it is the exact reason the exploitation was possible in the first place. He was, by every account, a quiet man. An engineer. Someone who spent a career building infrastructure for a city that never knew his name. He did not choose to become a cautionary tale, and there is nothing dramatic or cinematic about how his story actually unfolded, no confrontation, no dramatic reveal, just a slow accumulation of paperwork that took 3 years and a public guardian's office to finally add up. That, more than anything else, is the detail worth sitting with. The crimes that hurt the most people in this country rarely look like crimes while they're happening. They look like a woman who remembers your name. They look like a check you don't remember signing. They look, from the outside, like someone finally being taken care of. There is no dramatic final image to end this one on. No security footage, no courtroom outburst, no letter left behind explaining anything. What there is, instead, is a public court file in Cook County, Illinois, with a case number attached to a man's name, documenting in flat legal language exactly how much of his life was taken and by whom. That file is the only monument this case produced. It is not much. For a man who spent his career building things the public would use without ever knowing his name, it may be the closest thing to a fitting one, a record, plain and unadorned, that says, "This happened, and it was written down, and someone was finally made to answer for it." If this case affected you, or if you have an elderly parent or relative living alone, the National Adult Protective Services Association and your state's Adult Protective Services Office are trained specifically to investigate concerns like these. Reporting a suspicion, even if you're not certain, costs nothing and could matter enormously. If you want more cases like this one, hit like, drop a comment with your thoughts, and subscribe to PalimpSestCrimes. We're back next week with another investigation.